What is the new copyright directive?
The new copyright directive for the digital single market is one of the boldest but highly controversial steps which the European Commission and the European Union has taken as far as the digital agenda is concerned and as far as revising our European copyright laws. It tries to bring our applicable copyright rules, which emanate from the 2001 Copyright Directive, to the 21st century, bringing them up to speed to technological developments which were experienced with the rise of the internet. We will definitely going to hear quite a lot about it. The jury is still out whether it was a good idea or a bad idea, but definitely some sort of revision or rehash of certain fundamental rules was definitely required.
Why did we need the directive?
The directive was indeed required due to the fact that when the Copyright Directive of 2001 was prepared, we were living in a world without YouTube, without social media, without a high dependency on the internet, and therefore those rules did not reflect the kind of usage or usability that we do with content. Now everything is moving online, all content is available online, but the rules which we introduced in 2001 did not reflect this kind of reality. And the European legislator tried, and I say tried because again, we do not know yet whether this will be successful or not, to revise those laws and bring them at par with technological development. There will be definitely issues as to whether certain aspects of the new copyright directive will impinge on, for example, freedom of speech. There is a lot of debate still ongoing, even though European Parliament voted in favor of this new directive, as to whether Article 17 of the directive will actually impinge on freedom of speech.
What are the main controversies relating to the directive?
Definitely, the biggest controversy is in relation to the upload filter, which is found in Article 17 of the new directive. By virtue of this upload filter provision, service providers such as YouTube, for example, will have an obligation to actually ensure that all the content which is uploaded on their site is licensed. They can do this either by obtaining a license or an authorization from the license holder, from the copyright holder of the content being put on their systems, or else they need to make sure that the content is not breaching any copyright of third parties. This will be highly controversial. There are already systems in place which are not perfect, which filter such content before it's being uploaded, and it definitely caused a stir as far as freedom of speech is concerned. This is also due to the fact that systems are not perfect, especially when you try to match them with the exceptions and limitations also found in the law. For example, you would not be breaching any copyright if you upload a video where you're making a review or a parody of copyrighted content. However, these automated systems which service providers will try and put in place will not have sufficient intelligence to actually establish whether that content is actually allowable under a specific exception or not.
Are we limiting the mere conduit provisions?
Indeed we are. And we are again re-establishing a new baseline as far as the responsibility or the liability of intermediaries and service providers. Till this day, we always relied on the provisions, the mere conduit provisions as found in the Electronic Commerce Directive of the year 2000. With the new EU Copyright Directive, we're limiting the possibilities of service providers, again, such as YouTube, to claim that they are not responsible for the content because they were just offering a service. With the new Article 17 of the EU Copyright Directive, those things will change, and service providers will need to ensure that they put everything in place and take all organizational and technological measures to ensure that there is no actual copyright infringement being carried out on their systems.